Following on from my previous video about wills, we're now looking at another area of estate planning, and that is the payment of a death benefit from superannuation. With over $2.9 trillion invested in the superannuation system, and that number keeps on growing, it really is an important area of advice. Now, the payment of death benefits from superannuation can be quite complex because you have to consider not only who can receive the benefit, but also how to give them the benefit and the tax implications that may apply. So while I'm going to try and keep this video as simple as possible, please forgive me if I enter into the realm of complexity a little bit too much. So grab yourself a coffee, switch your brain into thinking mode, and let's get started. Hello guys, Brad here from The Guided Investor. Welcome back to the channel for another video. If you're new here, consider hitting that subscribe button because I post regular videos about how you can do more with your money. And today we're talking about death benefits payable from superannuation. And this isn't the most exciting video I've ever put together, but it is an important one. Your superannuation death benefit is going to be made up of potentially two things: your accrued super balance and any life insurance that you may hold through your super fund. You can direct who receives your death benefit via a nomination of beneficiary. Now, if you list a person or people and it's a valid nomination, then the death benefit's going to be paid directly to them and it doesn't form part of your estate. The first thing you need to do is to consider who can actually receive your death benefit. And in order to do that, we look at the Superannuation Industry Supervision Act, or also known as the SIS Act. A superannuation death benefit can only be paid to someone who is listed as a dependent under the SIS Act. And in addition to the SIS Act, you should also consider the Income Tax Assessment Act, as this is going to determine if there's any tax payable. But I'm going to touch more on this later. Ideally, you're looking for someone who is classified as a dependent under both acts. And this is going to mean that they're eligible to receive the payment, and if it's paid as a lump sum, there's going to be no tax payable. Now, most commonly, this includes a child under the age of 18, an eligible spouse, or someone who you are in an interdependent relationship with. So that basically means you live together and you rely on each other personally and financially. To give you an idea of the overlap between the two acts, have a look at this little diagram. As you can see, a child of any age is a SIS dependent, but only a child under the age of 18 is a tax dependent. A former spouse is considered a tax dependent, but only a current spouse is considered a SIS dependent. This means you could pay the benefit to an adult child with tax penalties, but you couldn't pay the benefit directly to a former spouse. If you don't have any dependents under the SIS Act, then this means that your superannuation death benefit is going to be paid to your legal personal representative, and it's going to get dealt with by your estate. So this is the person who is the executor of your will. A death benefit can be paid as either a lump sum, or in some instances, you can also pay the death benefit as an income stream. Now, if your superannuation is not already in pension phase, then in order to pay it as an income stream, you need to be a SIS dependent, and this includes the following people: a spouse or de facto, a financial dependent, an interdependent relationship, a child under 18, a child aged 18 to 25 and is financially dependent, or a child of any age that's permanently disabled. Where the death benefit is paid as an income stream to a child under the age of 18, when that child reaches age 25, that income stream needs to stop and the benefit must be commuted and paid as a lump sum. Now, that doesn't apply if the child is permanently disabled. If the death benefit is being paid from an existing superannuation income stream, so before you pass away, you have a pension account set up, such as an account-based pension, then this pension can continue to be paid to the nominated beneficiary, provided you have a reversionary nomination in place, and I'll touch on this again a little bit more later. Please be aware that anytime you pay a death benefit as an income stream, then you need to consider the transfer balance cap. So basically, every person has a transfer balance cap limit of $1.6 million, which is indexed in the future by $100,000 increments, but you need to work within that transfer balance cap limit. Now, there are special rules as well that apply to children. If the beneficiary that you're passing the funds on already had a pension account set up, and as a result, they already had a transfer balance cap account set up, then the amount that you pass on to them as an income needs to fit in with their leftover transfer balance cap. If not, the balance needs to be paid out as a lump sum. Whether or not a death benefit is taxable is really going to depend on two things. It's going to depend on how the benefit is paid, so whether it's paid as a lump sum or an income stream, and it's also going to depend on if the person, the beneficiary that's receiving the funds, is a financial dependent under the Income Tax Assessment Act, which we touched on a little bit previously. Just to recap, a dependent under the Income Tax Assessment Act includes a spouse, including your de facto partner or a former spouse, a child aged less than 18, any person with whom the deceased person had an interdependency relationship with just before he or she died, or any other person who was a dependent of the deceased person just before he or she died. If the payment is taxable, then you also need to understand the components that make up a super fund in order to understand the tax implications that are going to apply. So there's basically three types of components that are going to make up your super fund, and they are as follows. Taxable tax. This is derived from concessional contributions such as employer contributions and investment returns. Taxable untaxed. This is derived from some death benefit insurance payments and money from an untaxed superannuation scheme like GESB West State Super. And tax-free, this is derived from non-concessional contributions, government co-contributions, low-income super contributions, eligible spouse contributions, contributions under the small business CGT concessions, and contributions related to personal injury payments. So all super funds are going to be made up of one or more of these components. Now, for most people, a large portion of their balance is likely going to be taxable because taxable funds are derived from employer superannuation guaranteed contributions, which for a lot of people out there makes up a significant portion of their balance. So now that we understand who is a dependent under the Income Tax Assessment Act, and we understand the different components that make up your superannuation fund, we now can look at the different scenarios and have a look at the tax implications under those scenarios. So this table summarizes the tax treatment of a lump sum payment. So if you make payment to a dependent, then the whole amount is going to be a tax-free payment regardless of the components that make up that super fund. If you make payment to a non-dependent, then there's going to be no tax payable on the tax-free component, but there will be some tax payable on the taxable component. So the tax element, you're going to need to pay 15% plus Medicare levy, and the untaxed element, you're going to need to pay 30% plus Medicare levy. This next table summarizes the tax treatment of an income stream payment. Now, please remember that a death benefit income stream cannot be paid to a non-dependent. So the tax treatment is going to vary depending on age. So if the deceased and the dependent is less than age 60, then there's going to be no tax payable on the tax-free component, and there will be some tax payable on the taxable component. So the tax element will be taxed at the beneficiary's marginal tax rate less 15% tax offset. The untaxed element will also get taxed at the beneficiary's marginal tax rate without the 15% tax offset. If the deceased or the dependent is age 60 or more, then again, the tax-free component, there'll be no tax payable on that. There'll also be no tax payable on the taxable tax element, as this is classified as non-assessable, non-exempt income, so it doesn't even form part of the tax return. The untaxed element will be taxed at the marginal tax rate less a 10% tax offset. So in summary, the tax-free component of your super fund is always going to be paid out tax-free, whether it's paid as a lump sum or an income stream, and regardless of if it's paid to a dependent or a non-dependent. Now, where tax implications come into play is the taxable portion of your super fund, and the tax implications are going to depend on how it's paid and who it's paid to. Given the very favourable tax treatment, whether the deceased is age 60 or more, a reversionary nomination is a very popular choice where an existing pension account has been established. And I'm going to touch on this a little bit more later. When the trustee of a deceased estate receives a lump sum death benefit, it's going to get taxed in the hands of the trustee according to whether or not that's going to be paid to a dependent or a non-dependent. By nominating a beneficiary, you are instructing the trustee as to whom you'd like to receive your death benefit in the event you were to pass away. When it comes to nominating your beneficiary, you normally have a few different options to choose from. And it's important that you understand these options around the type of nomination, because at the end of the day, certain nomination types are going to give you greater control than others. The three main types of nominations are as follows. A binding nomination. As the name suggests, a binding nomination is binding to the trustee provided you've met all the legal requirements. Binding nominations can generally be both lapsing and non-lapsing. If it is a lapsing binding nomination, it will automatically expire every 3 years and you need to renew it. If it is a non-lapsing binding nomination, it will not expire. Non-binding nominations. If you make a non-binding nomination, this is an indication to the trustee as to whom you'd like to receive your super funds, but ultimately, the trustee has the final say over the distribution. If the trustee feels your non-binding nomination is not appropriate, they can pay it out to a beneficiary whom they believe is a better claim to the money. And a reversionary nomination. If you have a pension account established, you can list a reversionary nomination. Under this arrangement, the pension account will continue to operate, but the ownership will be transferred to the nominated beneficiary. This is particularly useful if you want to keep the funds held in a tax-free pension environment. Just remember, there are transfer balance cap limits to take into consideration with this style of nomination. So the type of nomination that you choose really is going to be dictated by your family situation and whether or not your super balance is in accumulation phase or pension phase. When you make the nomination, you can either list an individual person or people, or you can list your legal and personal representative, which is basically putting the funds to your estate. If you fail to make a nomination of beneficiary, then ultimately the decision as to whom receives your super death benefit is at the discretion of the trustee. Now, generally, the trustee is just going to pay it directly to the state, but they can pay it to an individual person if they feel that is appropriate. But best to take the ambiguity out of the situation and just make a nomination of beneficiary. Nominating a beneficiary is a very important aspect of your overall estate plan, but it often gets neglected. And like with other elements of your estate plan, it's not about making your life easier, it's about making the life of your loved ones easier if you were to pass away. In order to make that nomination, you simply need to contact your superannuation fund, ask for the relevant paperwork, and complete it and send it back. Now, if you're still unsure as to whom you should list as your nominated beneficiary and you don't really understand the tax implications, then it's best to seek professional advice in this area. Moving forward, if there's a significant change in your situation, then you should review your nomination of beneficiary along with the other areas of your estate plan. But that's it for me today, guys. Thanks a lot for watching. If you're still with me at the end of this video, then kudos to you because it's been a bit of a long one, a bit of a technical one, not very exciting, but it is important. So I do hope you got some value out of it, and I will see you guys in the next video.